My name is Cynthia Mason. I'm a Canadian lawyer and trademark agent, and I specialize in helping businesses protect their brands in Canada. And in this video, I want to talk about how you protect a name when you haven't trademarked it or you can't trademark it. So there are, under Canadian law, names must meet certain minimum criteria to qualify for trademark protection by way of a registration. The biggest reason why a name would be refused a registration for inherent reasons, so something wrong with the name itself, absent whether somebody else has already trademarked it, but a name has to be distinctive. It has to be capable of distinguishing one particular source of products or services. And the biggest reason why a name generally is considered not to be inherently distinctive is because it is descriptive or it's a generic term in your industry. And so one of the things that we always talk about in free consults with new clients is your name something that would meet the inherent distinctiveness requirements under Canadian law? Because a name that clearly tells the public what it is you're selling or the result of your services or a particular feature of your products, if your name clearly articulates that to the public, the Trademarks Office is not going to grant you a registration, which is basically a grant of the exclusive right to use that word or that term in connection with products and services. When it comes to descriptive and generic words and terms, the Trademarks Office takes the position that these should be available to everybody in an industry to use to describe their own products and services. So they don't like to grant trademark registrations for descriptive or generic words and terms. Now, just because your name may be considered descriptive or generic does not mean you cannot continue to use that name. That name will certainly have challenges in terms of marketing it and trying to keep it exclusive, but you can generally use a descriptive or generic name. And you can try to protect it as your exclusive property using other elements of trademark law beyond registration. Now, I will also say that if you use a descriptive word or term and over time you heavily market it and you become exclusively known for its use in your industry, you may be able to qualify for trademark registration at that point. But that's years into the future, and that's a significant investment in marketing and advertising and sales. So what do you do in between adopting a descriptive name and being able to register it as a trademark because it has become known exclusively as your brand? There are things that you as a business owner can do, and they include the following. One, use the trademark symbol. Just because it's descriptive doesn't mean you can't try to claim it as your trademark. And when you mark it with the TM symbol, that is telling the public that this is a trademark. This is an unregistered trademark. A lot of business owners think that the TM symbol is only available for marks that are pending registration, so that you have filed an application and it's kind of like patent pending, but for your trademark. That's not true. The TM symbol is available to anybody using an unregistered trademark, whether or not you have filed a trademark application. And it is the best way to tell people looking at your marketing that this is your trademark. So use the TM symbol. That is the first thing that you want to do. The next thing that you want to do is ensure that you are treating that name as a brand name and not as a descriptor for your products and services. So oftentimes, marketers and business owners, they want their brand name to be, have this kind of cachet to it, or that people, instead of referring to the product, they're just going to refer to the brand name. And this is actually a terrible strategy, and is something that you don't want to have happen under trademark law, because if you treat something as a descriptor and not as a brand name, then the public is going to treat it as a descriptor and not as a brand name. Instead, you want to treat your name as a brand. And the kind of like the subtle ways that you do that in your marketing is you don't use it as the noun for your product or service. You use it more as an adjective to describe the noun for your product or services. And in this way, you are reinforcing to the public that this is a brand name. It is not a descriptor of what you're selling. The third strategy, a third thing that you're going to want to do, and this is probably going to cost you the most money out of all of the strategies, is you have to enforce your exclusivity over this name. It will be challenging because it's descriptive and it starts out descriptive, but the more that you use it, the more you are building trademark rights in it. And you want to be able to point to those trademark rights through use. We call them common law trademark rights. You want to use those rights as the basis for claiming that the public knows my use of this name as a brand name. And so your use of it as a brand name is actually going to cause confusion. And so it really is about adopting a very aggressive and diligent enforcement strategy to try and maintain your exclusivity over the use of this brand name. There are ways that you can certainly enforce an unregistered trademark, particularly one that is, borderline descriptive and very challenging to protect. So long as you take an aggressive approach to it and try to maintain your exclusivity, like I said, you will move from this point where it is a descriptive or generic word or term to something that is so exclusively associated with you that it is morphed into this registrable trademark and it is your brand name. You have to kind of maintain exclusivity for that to eventually happen. The next kind of legal strategy or the final thing that you may want to think about is filing a trademark application for it. Even though there is a very low chance that it will go through to registration, if you file your trademark application and you kind of keep it, pending throughout the process, and in Canada, the trademark process can take several years, you get your name on the register, your application goes through the process, you're kind of on the register before anybody else can take that strategy. And so you're kind of keeping your space in line on the trademarks register to register this name as your trademark. You can go through the process. If it's refused, if it is looks like it's going to be refused, you can withdraw it and refile it so that you're constantly keeping a placeholder in line as you build your rights of exclusivity in this name. So these are kind of the ways that you can continue to try and protect yourself if you have a name that doesn't meet the criteria for a trademark right now. So once again, you've used the TM symbol. Don't use it to describe your products and services. Use it as a brand name and really highlight it as a brand name in your marketing. Keep your exclusivity, enforce it. You're building trademark rights or you're budding trademark rights against people who would come along and try to use your brand name, even though it might be descriptive, who try to use it in their own marketing. Maintain your exclusivity by enforcing your rights against those third parties. And then think about filing a trademark application to kind of keep your place in line to register it eventually. If you would like some very specific and strategic advice about your own brand name and are looking to get a little bit of guidance on what you can do to protect your brand name, reach out to me, book a free consult at MasonPC.com or through Markably.ca. I'm happy to give you my thoughts on what you can do to protect your own brand name.